Good afternoon, everybody. Thank you for joining us for another webinar in the Conn Maciel Carey 2015 OSHA webinar series. So excited that you all could join us today. This is more of a process topic. Everything up to this point, we've talked about some interesting substantive issues, areas where OSHA has turned its enforcement attention or proposed or enacted a new rule. Today we're talking about process. And that is the process of an OSHA inspection, how you can best prepare yourself for an inspection, and then once OSHA does knock on the door, how best to manage the OSHA inspection. So really the webinars up to this point in the series have maybe been a discussion about why it's important to prepare for an OSHA inspection, the issues that you need to address from a substantive standpoint or understand that OSHA is going to address from a substantive standpoint. And now we'll talk about, how to prepare for the actual process of OSHA touring your facility, interviewing your employees, reviewing your documents, and formulating perhaps an enforcement action to assign to you and to issue to you as proposed violations. I'll give you a little bit of background here quickly about the voiceless or the faceless voices that you have coming out of your computer screen or over your telephone, so you know who you're talking with. This is Eric Conn. I am a founding partner and chair of the OSHA Workplace Safety Practice Group at Conn Maciel Carey. My practice focuses exclusively on workplace safety and health law issues. That means primarily I am helping my clients deal with all manner of issues related to OSHA enforcement, and OSHA regulatory matters. But there are also a host of other agencies that get involved or overlap in that workplace safety and health arena, like the U.S. Chemical Safety and Hazard Investigation Board, the CSB, the Mine Safety and Health Administration, and the EPA. I help my clients respond to and manage investigations and inspections involving catastrophic industrial, construction, and manufacturing workplace accidents, including explosions and chemical releases. And then at the end of the inspection process, I help my clients manage enforcement actions, from appealing citations and litigating against OSHA to resolve those citations, to criminal investigations and criminal prosecutions under the OSHA Act or state criminal cases. I write and speak regularly about safety and health law issues and work with my clients to develop and implement and audit safety and health programs. I'm joined today by my partner down in Atlanta, Amanda Stratus-Walker. Amanda, if you're online, I'll have you introduce yourself.
Hi, everyone. My name's Amanda Stratus-Walker, and I work with Eric. I've been working with Eric for the past 4 years, and my practice covers a large extent to what he just mentioned, occupational safety and health, a subject matter that I started focusing on about 10 years ago when I started working for the Department of Labor, first in OSHA and then later in the solicitor's office working on occupational safety and health issues. Like Eric, I represent a variety of clients in the private sector and then also some trade associations with regards to regulatory issues that their groups face, handle everything from the litigation to compliance matters. And like Eric said, sometimes the majority of the work involves OSHA, but sometimes some other federal agencies do get involved.
All right, so what are we going to talk about today? We're talking about the OSHA inspection process, but before we get into sort of the stages of an OSHA inspection, we'll start off talking about the various rights and responsibilities of the players involved in the process. That's OSHA, that's you, the employer, and your employees who have rights to participate in and, in fact, to trigger OSHA inspections. We'll also talk a little bit about how to prepare in advance for an inspection. So, by the time you hang up the phone today, by the time this webinar ends, you'll have a handful of new tools to go out, things you can do now to put in place before you get that visit from OSHA to make sure that the inspection itself is smooth. And then the last thing we'll talk about is how to manage an ongoing inspection. We'll walk through the various stages of the inspection, the various events and activities that you can expect to happen during the inspection, and talk about some tips and strategies for how to handle those including some of the post-inspection considerations. So let's jump right in. Me, whenever I talk about the OSHA inspection process and think about how to manage an inspection, it really makes sense to first talk about your goals or the goals that I think employers should have related to OSHA inspections. That's going to help guide all of the tips and strategies that we talk about today, is thinking about what are we trying to accomplish. And the number one goal, the one that I think about most often when I'm helping employers manage inspections, is controlling the flow of information. This is not about hiding things under the rug or changing facts or anything like that. It's all about controlling when, how, and the scope of what OSHA digests during the inspection process. OSHA is going to request all sorts of information in document requests. They're going to request to interview lots of employees and dig through all of this material at your facility. So you want to control the scope of records that you produce, the light that they are seen in, when in the process they're shared with OSHA. In terms of interviews, you want to control when interviews are happening and how information is conveyed during those interviews. And all of the strategies that we're going to be talking about today in terms of preparing for the inspection and what you do during the inspection are geared towards controlling that flow of information, making sure that A, you know what's going out there to the agency, and B, you have some control over when it is shared, in what format it's shared in, the volume that is shared, as a way to manage the inspection and drive the best possible result. Another goal that sort of works hand in hand with the controlling the flow of information is minimizing business disruption. This is an important element of managing an OSHA inspection because the process can be very disruptive. There is really nothing like having a government agency walking around at your facility to change the way your employees do work. It's going to require, first of all, you to deflect or redirect employees' work activities. OSHA is going to be asking for all sorts of information, and they're going to be asking for these interviews, and that's going to require you to pull people off of their normal work duties and have them pull together documents to share with OSHA, or have them sit down in a conference room and be interviewed by OSHA. And these things can be very disruptive to the workplace. If all of your employees or several key employees have to stop what they're doing from a production standpoint and deal with the OSHA inspection, that could cause you to essentially shut down operations if they're key roles and you don't have backups ready to fill those roles. So very often we can point to this disruption, and OSHA has a duty that we'll talk about to be reasonable in its inspection and to disrupt the workplace as little as possible when conducting an inspection. Well, that right, it's actually a right that employers have to a reasonable inspection. That right to minimal business disruption allows you in a lot of ways to control the flow of information. Because if OSHA comes in and says, we want these 10,000 records and we want them in the next 3 hours, well, that's going to require you to basically pull all of your manpower off of what their normal job duties are to go round up documents, photocopy them, prepare them to produce to OSHA. Well, that may not be a reasonable request, and it doesn't sound like a reasonable request to me. So you can push back a little bit and say, that would be very disruptive to our workplace. How about instead we produce this smaller set of documents or pull these employees off for interviews after lunch, one at a time, and set the schedule. So you use the prospect of an unreasonable disruption in your business to control the flow of information. When OSHA gets access to certain information, the format and the scope and the volume that they're going to get, these things go hand in hand. Another goal of managing an effective OSHA inspection is to cast your workplace in the best possible light. So much of what comes out of an inspection, so much of what an OSHA enforcement action is ultimately going to look like has to do with the tone of the inspection and the perception that OSHA has about your workplace, about your safety program, about your written procedures, and about the quality of implementation of those programs at the workplace. So a major goal of the inspection is to cast those programs, cast your physical workspace in the best possible light. It's not always about the four corners of the piece of paper. It's often about a perception. And so your goal is to make the perception of your safety program as positive as possible to drive a good result out of the inspection. And then a final goal, as I see it, is identifying potential problems early. Preferably identifying them before the compliance officer does and addressing them. But if it happens to be after the agency has recognized the problem, you want to identify it as quickly as possible, A, so that you can address it and perhaps earn some good faith points. And if you address it, although without admitting that there was a violation, we'll talk about that in more detail, perhaps it just becomes a finding and verbal recommendation by the compliance officer rather than a citation. That's not always the case, but the quicker you jump on it, the better it is, or the more likely it is that it won't result in a citation, or at the very least that you'll get good faith credit when they calculate penalties and characterization and things like that. But also, if you identify a potential problem early and it's not actually a violation, it may appear so to the compliance officer, identifying the issue early will allow you to sort of nip the issue in the bud. Talk to the agency about why it's not a violation. Present additional information or documents that show why it's not a violation. Because if you can dissuade OSHA from issuing something as a citation, it's much easier at the end of the day to have that item not cited, nip it in the bud, than it is to get OSHA to withdraw an item in the contest process. Not impossible, obviously. That's what we do all the time, but it's much easier to nip it in the bud than it is to deal with it after the citations have been issued. So an important goal here is to identify problems early and either try to persuade OSHA that they're wrong or address the issue so that you may avoid a citation just by having jumped on it so quickly. So moving from the goals of the inspection, let's think about some of the tools that employers have to affect those goals. And the most important tool to me comes straight out of the language of the OSHA Act, Section 8A, which, in theory gives OSHA its authority to conduct inspections, but it also puts, in my opinion, great limitation on OSHA in conducting inspections. The language of the Act provides that OSHA may inspect at reasonable times any workplace during regular working hours and at other reasonable times within such reasonable limits and in a reasonable manner. Emphasis added by me, but it's repeated so many times there, it seems that the emphasis was also added by Congress when they implemented the OSHA Act. And what's key here is that OSHA must be reasonable. And, that means although they've got authority to inspect and they've got a badge and they are a federal agent or a state agent if you're in a state OSHA program, OSHA must be reasonable. They can't come in and demand that you turn over every record that's ever been created, shut down all your operations, and bring all of your employees up for an inspection at the snap of a finger. Their requests must be reasonable, the timing of the inspection must be reasonable, and their conduct during the inspection must be reasonable. I use Section 8A and the reasonableness requirement all the time during inspections to control the flow of information and to manage the inspection process in a timeline, in locations, and in a manner that we think is a way to best present our workplace in the most positive light. So remember that OSHA must be reasonable. Now let's talk a little bit about the rights of the respective parties who will be involved in an OSHA inspection. First of all, there's OSHA, and OSHA has the right to inspect workplaces, and that's set forth in Section 8A, or really overall Section 8 of the OSHA Act. The right to inspect workplaces, but that right is a limited right. It's a right that is limited to workplaces where OSHA has probable cause to believe that there is a violative condition present. And that's where the warrant requirement comes in, that OSHA, unless employers consent to an inspection, have to have probable cause and demonstrate that probable cause to obtain a warrant. They may also inspect with consent of the employer, and they may also inspect where there are violations in plain view from a place where OSHA is permitted to be. And that might be a public area where OSHA, out on the public road, and they can see employees working on a construction site and see that a violation is occurring, not wearing fall protection, working at heights, and they observe that in plain view from a place they're permitted to be. That gives them the right to inspect that work site. Otherwise, they need to have some reason to believe there's a violative condition at the workplace. And there are several ways that they, get this probable cause. One is through a credible employee complaint. Another is through an incident that they've learned about, either because you had to report it to them through their new reporting rules, or reported to them by an emergency responder or the hospital, or by the media who's covering a story about an injury at your workplace. Those would generally be triggers to establish probable cause for OSHA to conduct an inspection in your workplace. Another very common way is for OSHA to put in place a programmed inspection or an inspection program where they are targeting a specific hazard or a specific industry where they have good data to demonstrate that there are very often common workplace hazards present in workplaces covered by that inspection program. So, for example, OSHA is aware of and has followed the trend in engulfments inside of grain bins. And so as a result of a very demonstrable set of data that shows engulfments in grain bins occur, not infrequently, and they perhaps are occurring more frequently than they have in the past, OSHA can use that data to establish an emphasis program, a national or local or regional emphasis program targeting hazards at grain elevators. And using that inspection program, if they implement neutral selection criteria, so they're targeting an entire industry and pulling out individual employers within that industry out of a hat randomly, or using some list that is created in random order, if they're following that list and it's a neutral selection criteria within an industry that they have reason to believe there are common hazards, that is a way that the courts have determined that probable cause can be established. So they may not have any reason to believe there's a unique hazard at your workplace. They have been able to demonstrate that it is common that there are hazards at similar workplaces, and they've chosen your workplace basically randomly within that industry. That is a way to establish probable cause. So OSHA has that right to conduct workplace inspections in those circumstances. The most common, frankly, is that they're there for one of those reasons, but they actually get their authority by consent of the employer. The employer acknowledges that OSHA has a legitimate reason to be there, and they consent to the inspection. Without that, OSHA needs to go to a court and get a warrant to conduct the inspection based on those various triggers for an inspection that we just discussed. OSHA also has a right that their inspections can and should be conducted without advance notice. In fact, it is considered a criminal act for OSHA to provide advance notice of an inspection. So you are not likely to know that OSHA is coming. You may have a good idea that you're on a list. You know that OSHA is inspecting, excavations in your area. They've got an emphasis program targeting that. So you know you're on a list, but you don't know, OSHA is coming to visit you today or tomorrow. The reason for that is they want to catch you sort of conducting business the way you would when you don't know that OSHA is coming. It's the same way that your safety director probably doesn't announce their internal visits to the site. They want to sort of catch you operating in your normal operating conditions. OSHA also has a right to inspect records, collect physical evidence, and to conduct interviews. All three of these rights sort of roll up under OSHA's subpoena authority. They have the authority to issue subpoenas to require you to produce relevant documents related to the subject of the inspection or your safety program generally. The right to collect physical evidence, to take dust samples, to take air monitoring readings, to take a physical component from an accident site, subject to their subpoena authority. They also have the right to conduct interviews or to issue a subpoena to compel employees or employers to sit down for an interview relevant to the topics that they are inspecting. All of these things, we talk about OSHA's subpoena authority, just like the warrant requirement, where typically OSHA proceeds with consent of the employer. The same is true for all of these forms of evidence that OSHA collects. Typically, that is done on a voluntary basis. OSHA is going to issue voluntary document requests, voluntary requests for employees and managers to submit to interviews. If you refuse to provide records, or you or some of your employees refuse to sit for interviews, OSHA does have this authority to issue a subpoena to compel production of that type of evidence. Generally, just like the warrant analysis, we will generally follow the path of voluntary participation in those elements of the inspection, but use the voluntary nature to negotiate reasonable scope. If OSHA requests training records for the last 20 years, and that would take a truckload of records to satisfy that request, we might go back to OSHA and say, how about we give you the last 3 years of training records, or training records for just employees in this area of the facility, or employees just in this job role, and go from there. If you're dealing with a subpoena, it's more of a compulsory issue. There's not really any negotiation involved in that process. But if you're dealing with voluntary requests, you've got an opportunity to try to negotiate a reasonable scope. Likewise for interviews. If it's voluntary, you might be able to identify employers for OSHA to interview. You're looking to interview machine operators. How about we bring in, the 2 machine operators operating today, or we'll bring in 1 senior and 1 junior operator, and you get to pick them. If OSHA is issuing subpoenas, there's no negotiation in that area. It's going to be whoever's name appears on the subpoena. So that's OSHA's rights during the inspection. Your employees also have substantial rights during, before, and after the inspection process. First, they have a right to file a complaint with OSHA. They can contact OSHA before or during an inspection to raise safety and health related concerns. And they have a right to do that without being subject to discrimination or retaliation. We have seen over the last several years whistleblower complaints on the rise, and the penalties arising out of whistleblower actions to be very often much greater even than the substantive safety violations, the civil penalties associated with a citation. So very much caution you against taking any adverse employment action against an employee who may contact OSHA, who may trigger an OSHA inspection. Even if you think their complaint is wrong, it's invalid, don't take an adverse action against them. In fact, OSHA is not going to tell you who made the complaint. Often it's very obvious who did that, but I would avoid the impulse to try to find out who did it, because it's not going to do you any good to know who did it, because that can only lead to perhaps an inference that you've taken an adverse action against that employee. If you don't know who it was, it's hard for OSHA to prove that you've retaliated against them. Employees have a right to participate in the OSHA inspection process. Generally, this is done via an inspection representative. Perhaps if it's an organized workforce, a union representative would be there representing employees on behalf of the employees in the OSHA inspection process. If there's no union on site, maybe there's an employee representative of the safety committee who would be assigned to participate in the OSHA inspection, or a senior employee that has a trust of the other employees could be the one who participates. And that participation right includes sitting in on the opening conference, walking around with the OSHA inspector and the management representative during the walk-around part of the inspection. Employees, all of them individually, have a right to a private interview with OSHA. We're going to talk about this in some detail. There's a great conflict, a great tension between what I think the law is and OSHA's view of the law around interviews. OSHA believes that it is OSHA's right to conduct private interviews with non-supervisory employees. The law is actually quite clear that it is the employee's right to have a private interview if they want that, and the employees may waive that right if they'd like. We'll talk about that in more detail. employee representatives can participate in closing conferences, in informal settlement conferences, and all employees have a right to access records related to an enforcement action. The citations themselves will be posted. The pleadings and documents from the litigation process have to be kept and made available to employees upon request. An important issue here has evolved over the last several years based on a quirky and I think plainly wrong interpretation that federal OSHA issued about participation by third parties in OSHA inspections. And what this really was driven by was unions who wanted to use the OSHA inspection process as a way to infiltrate workplaces to help with organizing campaigns. And OSHA, basically going along with the will and interest of unions, put out a memorandum, an interpretation letter, basically a memorandum to the area and regional offices that just plainly misstates and flouts the regulations that apply to who may participate in OSHA inspections, and basically said that third-party union representatives or community organizers may participate in OSHA inspections even at facilities that are not organized, even at facilities that do not have a collective bargaining agreement. And if an employee, is basically OSHA's view, requests that one of these third parties step in as the employee representative during the inspection, they may do so. But that is plainly in conflict with the regulation and the law that talks about the very, very limited circumstances where third parties may participate in OSHA inspections. And generally that is limited to only circumstances where someone is a formal elected representative of the employees, an actual union that has been empowered to represent the employees through an organizing campaign and an election, or third parties that are not employee representatives but are there at the request of OSHA because they have special technical expertise to help OSHA conduct the inspection. This new interpretation has received a lot of pushback from the regulated community, and we have not seen OSHA attempt to do this very often. The really only one circumstance where I've seen OSHA try to bring a union that does not represent employees at a workplace, the employer properly pushed back and said, we will consent to the inspection by OSHA, but we do not consent to letting this third party, who is not our employee, come onto our property. And OSHA had a choice to make whether they'd fight this, whether they'd go try to get a warrant that included this third party, and apparently OSHA elected to just proceed with the inspection without the third-party representative. But that's been an interesting issue that we've been monitoring in terms of employees' rights during inspections. Finally, it may not feel like it during the process, but employers also have inspection rights. The first one we talked about already, that you have a right to a reasonable inspection at reasonable times, and we emphasize this over and over during inspections, that requests, that interview demands, that areas that OSHA wants to go to, scopes of the inspection. If any of it we don't think is reasonable, we push back and emphasize this right that we have. Employers have a right to demand inspection warrants. You have a right that OSHA must, you have a right to be free in your workplace from unreasonable searches and seizures, and therefore you have a right to keep OSHA off your property unless they have probable cause, and therefore you have a right to demand an inspection warrant. And we'll talk about when it might make sense to do that. You have a right to hold an opening conference, and this is a critical right. And I know Amanda is going to talk about the opening conference stage of the inspection in more detail, but in my opinion, this is probably the most important stage of the inspection. OSHA wants to skip it or get through it as fast as possible, because this is, OSHA gives no advance notice about the inspection, but then they show up and have to sit down in a conference room with you to talk about why they're there, what they intend to do while they're there, to give you time to decide whether you're going to demand a warrant and to really get the process started. Well, that is tantamount to advance notice, because OSHA knows that while they're sitting in the conference room talking about why they're there and what they intend to do, that managers are in the back of the house saying, hey, OSHA's here, OSHA's here. Let's get our stuff in order, get this place cleaned up, stop doing something that shouldn't be happening if something is happening that shouldn't be. So they want to breeze through that opening conference and get out there to the shop floor as fast as possible, see what's going on, start talking to employees right away. Well, you've got a right to this opening conference, and you've got a right to have your questions answered about why OSHA's there, what their intentions are while they're there, and to try to negotiate a reasonable scope of the inspection. Take advantage of that opening conference. First of all, you may learn during the opening conference that they're there for a reason that's just not valid. They're there based on an inspection program they have going that doesn't apply to you. This has happened numerous times where OSHA has showed up and said, we're here to do an inspection under this auto manufacturer's emphasis program that we have going, and we'll pull up the directive that OSHA puts out about that program, and we'll see that it says this program applies to employers who operate under the following SIC or NAICS codes. And we look at it and we say, wait a second, we don't operate under these SIC or NAICS codes. This doesn't apply to us. We present that to OSHA during the opening conference, and that ends the inspection. That's your last chance to do that, because once you consent to the inspection, even if it was improper to begin with, there was not a probable cause or a legitimate basis for OSHA to be there. Once you've consented, you've consented. So you've got to have that care and have those discussions during the opening conference, and that's your last chance really to stop an inspection before it starts. It's also your last chance to negotiate a reasonable scope over the inspection. If OSHA's there on an employee complaint, the complaint is about 2 subjects or 2 locations in your workplace, that's your last chance to say, we'll consent to an inspection, but only if you limit the inspection to these 2 areas of our facility or these 2 subject matters. And if OSHA doesn't agree to that limitation, it might be a circumstance where you say, just to be clear, we're consenting to an inspection to these 2 elements, but if you won't agree to that limitation, then we're going to demand a warrant, at least as it relates to other parts of our facility or other subject matters. So that's an opportunity to have that negotiation before you consent, before the inspection begins. It's your last opportunity to put those sort of limits in place. So critical right that employers have. Demand the opening conference if OSHA's trying to push past it. Sit down, ask all the questions that should be asked, take the consideration that you should take, and then make your decisions about how to proceed. And, if that takes a long time, it takes a long time. And if things are getting improved in the back of the house while you're doing that, great. That's a nice consequence of having an effective opening conference. I see a question has come in about opening conferences, timely, so I'll address that. Can OSHA deny participation in the opening conference and limit it to a general manager only? That's a great question. I don't think so. I don't think OSHA has the right to pick and choose who participates in the opening conference. First of all, they would welcome, OSHA always welcomes participation by non-supervisory employees, so they would want to open it up to a union representative or a employee on the safety committee or somebody like that to represent the employees' interests. And I don't think OSHA has a right to exclude managers of your choosing from the opening conference. And we'll talk a little bit about that. One of the only circumstances that I ever recommend demanding a warrant is if OSHA tries to proceed with an inspection before your selected inspection representative is present. Very often we might have our corporate safety director or me, the company's outside OSHA counsel, as a policy that those people, me or the senior safety representative or an in-house counsel or a chief operating officer, something like that, that person is the company's designated inspection representative. And if that person isn't present, they're in another state or they're at another facility, and it's going to take a couple of hours or maybe even until the next day for that person to be present, we ask OSHA to wait and say, sorry, our inspection representative is not here right now. He'll be back after lunch, or he can be here tomorrow morning. Can you come back then? If OSHA doesn't agree to wait and doesn't agree to let you choose your own inspection representative, then that's a circumstance, the rare circumstance, where I actually recommend at least threatening to demand a warrant until you can negotiate a time to start the inspection, or perhaps some middle ground solution where you share some records with OSHA, review our 300 logs while you wait for this person to be present. So I would say no, OSHA can't exclude managers of your choosing from the opening conference. They can't exclude managers of your choosing from participating in the inspection, either as the walk-around representative, interview representative for management interviews and things like that. But that's an interesting question. Yeah, there may be a reason if you've got a manager who's just butting heads with the COSHO and it's creating sort of hurting this casting the workplace in the best light goal that we have. It may make sense for you to exclude that person from the process, but OSHA doesn't have a right, I don't think, to exclude that person from the process. Other rights that employers have during the inspection process, if OSHA is there based on an employee complaint, you have a right to see a copy of the complaint. OSHA will redact from that the name of the relator, the person who made the complaint, or identifying characteristics. If it's a job title, day shift loader, well, that will tell you who it is that's made the complaint or make it easier for you to identify, so they'll redact that out. But the substantive elements of the complaint ought to be there. And if that is what is triggering an OSHA inspection, there's been a complaint, you should absolutely, ask for a copy of that complaint if OSHA doesn't give it to you voluntarily. If they refuse, and we've seen that a couple of times in California and some other locations, if they refuse to share it with you, that's another circumstance where I would push back very strong and even consider demanding a warrant, because you have a right to know what was the trigger for this inspection, because that's how you're going to negotiate the reasonable scope of the inspection. That's how you're going to look at the complaint and say, this complaint is only about, a safety issue or a safety component of my forklift. You're more than welcome to inspect the forklift. In fact, wait here in the parking lot. I'll drive it out of our warehouse into the parking lot. You can look at it there. It may seem silly, but, remember that plain view concept, that once you let OSHA into your facility, even if they're there just to look at the forklift, and you've negotiated that scope and they're only going to look at the forklift, if on the way to walking to where the forklift is located, they see a machine without a guard, an employee without a hard hat, and a chemical that's not stored properly, and they see it in plain view from the path that you have consented to let them walk on to get to your forklift, well, they've got a right to inspect those issues and include them in an enforcement action. So, look at the complaint, identify what the issues are, and try to limit the inspection to only those issues, and doing that in physical ways and with documents and interviews and everything. You have a right in the inspection process to protect your trade secrets and confidential business information. That doesn't mean that you can refuse to share it with OSHA, but it does mean you should give some thought to the records that you're turning over and how they might be used against you by a plaintiff's attorney, by a union, by the media, or by some other source. And if it's records that you would ordinarily keep confidential, then you should label them as such or communicate that in a way and effectively in a way to OSHA to say, we're sharing this with you, but we don't want you to produce this to the public in response to a FOIA request, and you have to protect these records from public disclosure. And we typically will put a label on the documents, use a cover letter that describes the records as confidential business information or trade secrets so that they can't be used or shared or disseminated publicly. Employers have a right to accompany compliance officers during the walk-around inspection. You should literally be attached at the hip to the compliance officer as he walks through the facility. And except when he's in the bathroom, you're with him side by side attached at the hip. You have a right, the employer does, to participate in management interviews. Talk about that in some more detail later, because that really is part of that tension where OSHA, I think, misinterprets its rights as it relates to interviews. Managers, even if they are sort of a disgruntled manager and they want to get a loan with OSHA and throw the company under the bus, management does not have a right to a private interview with OSHA. The company, a manager speaks for the company, and when evidence is being taken from the company, the employer has a right to be present when that is happening. So even if you have a disgruntled manager the employer has a right to be present during that interview, and that's an important right that we enforce very seriously during inspections. Employers have a right to a closing conference, and of course, they have a right to challenge citations. OSHA gets it wrong all the time. In fact, it is much more often than not that a citation that is issued is either withdrawn or amended in some meaningful way from the time it is issued to the time it becomes final. So OSHA is not the final word. You have the right to contest those citations and put them before a body of independent judges or at least to negotiate with the agency to try to address flaws in citations that are issued. I'll talk real quickly about some pre-inspection issues that you should think about, and then I'm going to hand it over to Amanda to talk about the stages of an OSHA inspection. So pre-inspection checklist, things to think about now. As soon as we get off this call, things that you can start to do to best prepare your workplace and your employees for an inspection. The first is define those emphasis programs, those inspection programs that I talked about earlier. Find the ones that exist in your geographic area and that relate to your workplace, your industry, the chemicals or the products or the materials that you work with, and understand what are the likely subject matters and likely inspection programs that will bring OSHA into your workplace. All of those programs have what's called a compliance directive or a directive that describes the inspection program. Find those online. You go to OSHA.gov under Enforcement and Emphasis Programs, and they will list all the national, regional, and local emphasis programs. See which ones apply to you, and there is a link on there to the directive that describes the program. Spend some time reviewing those. I think that is the most important thing you can do to prepare for an inspection. It's going to tell you, what are the likely reasons OSHA is going to come to your facility. These directives will identify the selection criteria, so you'll know if you're covered by it. You'll know how many workplaces like yours are on the list in your region to be inspected. And then they also guide the compliance officers in how to conduct inspections under those programs. So it might say, if it's the grain handling emphasis program, it will tell you how they're selecting and how many grain elevators they're inspecting. It will tell you what documents they're going to request at the beginning of the inspection. It will tell you the types of questions they're going to ask your employees during the inspection. It will tell you what programs they're going to analyze, and it will tell you the types of violations they're going to be looking for and that they're likely to issue during the inspection. You can use all of that information to assess your own programs. Do the inspection before OSHA gets there and see how you stack up against those elements and correct things before OSHA gets there. There's, I think, no better tool than looking at these emphasis programs and self-auditing against those programs to see how you stack up. I'd also recommend you look at OSHA's Field Operations Manual. It's sort of their version of this webinar that we're talking about today. You will find some distinct differences, but it's a great way to see how OSHA thinks and what they think their inspection rights are and how they're going to proceed through the inspection. So a really good perspective on the inspection process there. Auditing your written programs and auditing your physical facilities. I am a huge, huge component of audits and self-audits. I think there's no better way to identify gaps in compliance than getting in there with a professional and evaluating your status of compliance. I will tell you, though, that there is a potential downfall or potential downside to doing audits, and that is that OSHA can use them against you. If you do an audit and it identifies deficiencies or compliance gaps and you haven't addressed those compliance issues quickly enough, or you haven't addressed them before OSHA shows up unannounced to do an inspection, and OSHA gets their hands on that audit, it's going to be a roadmap for the agency to find the deficiencies and find the gaps, and it can be used as evidence against you for knowledge of the violative condition and even as evidence of willfulness, that you knew about the condition and you didn't address it, so you were plainly indifferent to safety and health of your employees, or you knew that you were violating a law and didn't come into compliance. So there's a downside there. So I will recommend, if you can, to do every audit that you can. I still encourage auditing, but I encourage you that you do your auditing under the protection of attorney-client privilege. So you get an attorney to direct the audit. Doesn't mean that I need to come through and actually do the audit for you, but I can engage a consultant at my direction as my technical advisor to audit your facility, audit your programs, to share that information with me, and I use that to give you legal advice, to identify deficiencies that you need to address. And that way the audit report, the work product from the audit, should be protected under the attorney-client privilege, so you don't have to share it with OSHA during an inspection. You may choose to do that. If the audit is completed, recommendations were made, and you've addressed all the recommendations, the audit becomes a great tool to show your good faith and to show how you've addressed issues whenever they come up, and to show that you had no knowledge of issues that weren't in that audit report. A very helpful tool. But if you haven't implemented all the recommendations yet, it's a great way to be able to say, sorry, we don't have any non-privileged audit materials we can share with you, and so you don't have to sort of set yourself up for harm by having done a self-audit. Last thing I would think about in terms of pre-inspection is think beyond a single facility. And this is a critical issue these days. It used to be that OSHA treated individual workplaces as individual standalone, basically standalone employers. And that was critical for purposes of repeat and willful violations. A violation at a facility in Illinois could not serve as the basis for, or would not serve as the basis for, a repeat violation at a sister facility within the same company in New York or even another facility in Illinois. Now, though, OSHA is looking beyond the boundaries of an individual workplace and treating all of the sister facilities within a corporate entity as a single facility for purposes of repeat violations and willful violations, and so you need to do the same thing. If you find issues at one workplace through an audit, or if one workplace is inspected by OSHA and gets citations, you need to map the learning from those events to all of your facilities, because OSHA is going to be looking beyond those boundaries and looking for and citing more repeat violations. Many of you I know joined me last month for a presentation about OSHA, the vast sort of increase in attention to repeat violations by OSHA, finding and citing more of these and using creative ways to find and cite more repeat violations. This is an important one, so you need to think beyond single facilities. And if you weren't able to join me for that repeat violation webinar, send me a note and I'm happy to share with you a link to the recording of that and the slides from that as well. So some actions you can take in addition before OSHA shows up for an inspection is to think in advance about who you would want to participate in the inspection and designate an inspection team. I've listed a bunch of roles here. This doesn't mean you need to have an 8-person inspection team, but it should be more than one person, and you should give some thought to who is going to be responsible for interfacing directly with OSHA, the primary spokesperson, escorting the compliance officer around the facility, who's going to take side-by-side photographs, if OSHA is going to take samples, dust, air, noise samples, who's going to be in charge of doing that or coordinating with a third-party service to do that. If you have a union or contractors on site, who's going to be in charge of interfacing with them to help manage the flow of information and to manage interview schedules and to keep track of what's going on with other employers perhaps being inspected simultaneously. So think about that, designate specific people to fill those roles, and then train those people in all the things we're talking about today. Who to contact when OSHA walks in the door, what are your rights and employees' rights during the process, how to manage and control the flow of information, understanding the key standards that OSHA is going to be looking at, and all of the tips and strategies that we're talking about today. Finally, think about where OSHA is likely to go, and then audit those routes. So, we talked about the complaint about the machine shop. The machine shop is in the back left corner of the building. That's an area where OSHA might pinpoint because of an employee complaint or an incident. So think about, how would I take OSHA to the machine shop if they came here for a limited inspection? And the best way might be walk around the outside of the building and come in the back door. But think about what are the discrete different areas of your facility and how you might get there, taking OSHA past the least sensitive areas of your facility. Think about that in advance. Audit those paths, audit those routes, and address any low-hanging fruit there. And then finally, provide inspection tools to your inspection team. You're going to make sure that you can take side-by-side photographs, so they'll need a camera. Think about who they're going to need to contact, the rest of the members of the inspection team, senior management, maybe your outside OSHA counsel. Put in place a contact list or a procedure that should be followed if an OSHA representative shows up. Tools to do side-by-side sampling, labels and logs to track document requests and to label things as business confidential. Those are all the things you want to think about in advance, have in place so that you can, in a seamless manner, jump right in and start the inspection process so you can cast the workplace in the best light, but at the same time control the flow of information without OSHA feeling like you're stymieing or interfering with their inspection. Final note here is about determining your warrant philosophy. I'll spend 2 seconds on this and then hand it over to Amanda. The Fourth Amendment applies. We've already talked about how you have a right to demand a warrant. I will just say my strong encouragement to you is that generally you will want to waive the warrant requirement and consent to an inspection, but only after you've negotiated a reasonable scope to the inspection. The reason why I discourage demanding a warrant is because even though it's illegal for OSHA to do so, there is a high likelihood that they will retaliate against you for doing it. It sends up a red flag that says, we've got something to hide here. It makes their job a little bit harder, and a government bureaucrat does not want you to make him jump through a bunch of hoops. He doesn't want you to make his job any harder. And if you do that, there is a good chance that they're going to nitpick every little thing that otherwise they might have just given you a verbal recommendation or just not have addressed at all. They're going to find a way to make your job harder if you've made their job harder. Now, that's improper. It's illegal, but they do it. They do it all the time, so you've got to be careful about that. But there may be reasons when it makes sense to do it. We've talked about that a little bit, so just think about that as well. So with that said, now OSHA's knocking on the door. What happens next? We'll let Amanda walk you through some of that.
Hi. Going to start talking about, so when OSHA shows up at your office or your facility and is knocking on the door, a lot of times they'll start off going to the receptionist desk and identify themselves, and we kick off what can actually be broken down into 5 different parts of an inspection. And we're going to talk about each one of these a little bit more in detail. Eric's already touched on some of them, but those are the opening conference, the walkaround inspection, employee interviews, and closing conference. And then post, if there are citations, and in about 75% of the cases, there are citations issued to employers in any inspection. And we'll talk about the considerations that you want to review when you're looking at a citation. So turning over to opening conference. As Eric mentioned earlier, this is probably one of the most important steps in the process. This is kind of where you're going to be setting the ground rules, getting the inspection off to the right start, and protecting your rights as well as recognizing OSHA's rights. OSHAs will arrive and they'll display their credentials. One of the things that we recommend in our inspection checklist is to always kind of have a note up front for your receptionist to refer to. Who are they supposed to contact when OSHA walks in the door? Sometimes it's not maybe as readily apparent as one might believe. So, letting them know, is it the supervisor? Is it the general manager? Making sure they know who to contact immediately to get the process started on the right foot. The next process, OSHA will generally show up. The opening conference begins. And, if there's employee representatives, a union there, an employee representative would have a right to participate in the conference. This is where the compliance officer is going to explain the purpose of the inspection. They're going to talk about why they're there. One of the things that we've seen recently is with the new reporting requirements for amputations and hospitalizations that went into effect in January, seeing a lot more inspections spurred by that. So they're going to tell you the purpose of the inspection, whether it's complaints, whether they're there on a national emphasis program, or even if they saw something in plain sight, which typically happens more in the construction context, but can also happen in general industry. And they're going to, based on the basis of their inspection, they're going to determine whether you're going to determine and discuss with OSHA whether it's going to be a wall-to-wall inspection, an overall comprehensive inspection, or if it's just going to be limited to a particular area. Say, for an example, a piece of machinery was involved in an amputation. That would typically just be the machine and not an overall inspection of the facility. As Eric talked about, it's also during this period that you're going to resolve the warrant issue, whether you're going to request one or whether you're going to comply with their request to proceed with an inspection. And also during this opening conference, OSHA is going to, especially in cases where it's a national emphasis program and they already have pre-printed sheets, provide you with a list of requests of documents they'd like to see. However, regardless of what type of inspection it is, usually you can always expect to receive a request to see your OSHA record-keeping logs. That would be your Form 300s, 301s, and possibly a summary depending on the time of year. And so those are something that OSHA always usually asks for. And it's also important to remember that there's a time frame. Usually that's one of the few, if not only, document that has a time frame on it. And I believe that it has a 2-hour from the time that OSHA requests the record-keeping logs. I believe it's 2 hours that there's a time frame on that in regulations.
There was a press release today about a serious enforcement action out in Kansas where they talked about the 4-hour requirement to get.
4 hours. Sorry.
Rarely cited, but it was cited today. I thought that was interesting.
Yeah, that's actually, I think, one of the first times that I've actually seen it cited, but it's 4 hours, and so that's one of the requirements. Just moving on to some practitioners' tips with regards to opening conferences. You know, when OSHA walks in the door, they might not necessarily always volunteer to have an opening conference, but it's something that is in their field operations manual. Employers have a right to request an opening conference. Cannot encourage enough that you take this opportunity to sit down with OSHA to kind of learn why they're there and basically kind of scope out what their intentions are. Do they intend to interview employees? Do they intend to do a site inspection? How broad is that site inspection? It's good to sit down and do these things before you get out into a production area where OSHA's eyes can start to wander and the opportunity for increasing the scope of the inspection exists. It's also, when you're having opening conferences, it's kind of a good idea before OSHA ever shows up and in preparation for an OSHA inspection to kind of be running through your head where you might be holding this. Typically, it's a lot of times in a conference room where there's not a lot on the walls. Certainly want to make sure that there's not anything that piques OSHA's interest, something maybe written on the whiteboards with regards to recent injuries, just making sure that the environment is as sterile as possible so that it doesn't prompt any additional questions from OSHA. But conference rooms are generally a good place for those opening conferences to start. It's also where you're going to be introducing the inspection team, whether it consists of one person or several. I'm going to explain and request that OSHA write if they have any document requests, if they do submit them in writing, and we'll talk about that in just a minute in a bit more detail. Establish interview protocol. A lot of times OSHA likes to stop by and talk to people as they're doing work, but if OSHA does have a need to talk to an individual, setting up rules to arrange those interviews. And then, particularly if it's going to be a long-term inspection, something that's going to last, an inspection where OSHA is going to be on site for multiple days or for an extended period of time, maybe over months, it's always a good idea to request a closeout meeting at the end of each day. And these closeout meetings are hugely beneficial to determine what OSHA wants to do the next day on site. So you're kind of planning ahead. Do they want to do employee interviews? Do they want to go see a particular area of the facility? It gives you a heads up on what they're planning on doing when they come back. And also kind of another thing you'll want to discuss, and we'll talk a little bit more on document production, is to arrange the review if OSHA does decide to take any photos as they walk around the facility, an opportunity to view those photos to make sure that there's no trade secret or CBI information contained in them. So kind of setting the ground rules Our inspection checklist goes over this in more detail, but those are some of the high-level key points that we consider important to discuss during an opening conference. Moving on now to the document production. A lot of times this might not, as I mentioned before, might not necessarily start off in the opening conference. A lot of times if it's a national emphasis program, they'll come into your office with a pre-printed list of documents that they want to see, and they'll submit it to you. If it's more of an injury or a incident or complaint, they might not have that list prepared, but generally every inspection does include some sort of document request. And I can't emphasize enough how important it is to have those requests in writing. And the reason for that is clarity. Currently working on an inspection right now where there was a request for a lockout tagout program, and the general lockout tagout program was provided to the compliance officer, but the machine-specific protocols or procedures were not provided. And so now we're dealing with OSHA deciding and trying to explain that they were never requested, or we never understood that the request was made. And it's just easier up front if you have something to point to. This was a written request, and this is the documentation that we provided. So encourage employers to do that. It can be as simple as a compliance officer taking a notebook piece of paper out of their notebook and doing some handwriting and submitting that. Does not need to necessarily be a formal document.
Another great advantage to the sort of insisting that document requests be put in writing is that during the walk-around process, it's very common for a compliance officer to just sort of spout off a bunch of stuff he's interested in. Oh, I didn't know you had that kind of machine. I'd like inspection records related to that machine. Oh, I see you've got a bulletin board about audit reports. I'd like a copy of all your audit reports. Oh, I see that you've got this process. I'd like to see your operating procedure for that process. And I just sort of nod and say, sure, just put it in writing and we'll be happy to get that to you. At the end of the walk around, you get back to the conference room, he's either forgotten half the things that he asked for, or realizes he doesn't really need it, or doesn't want to take the time to put it all in writing. And so, those disappear. If you've agreed to a protocol that document requests will be put in writing, anything that they just sort of spout off about and doesn't get recorded in writing, then you don't have a responsibility to address that, because you can go back and say, look, this is all that we are aware of you've asked for. This is what your written requests are, and that's it. So it's a nice advantage there, too.
Moving on and discussing voluntary versus subpoenas for written documents. Generally encourage voluntary submission of documents, and the primary reason is you have more flexibility in providing the response. OSHA might be able to say that they want to see the last 5 years of a particular document. Maybe they want to see the last 3 versions of your standard operating procedures for a particular process. And instead of providing the last 3 versions, just providing the last version to OSHA, you have more flexibility in what documents you provide to them. We sometimes parse those written requests, and we'll provide them, like I indicated, like the most recent version and not necessarily all the previous versions. But we're always very clear with OSHA. We do cover sheets, indicate the information that we're providing to them, and see if they come back and ask an additional question. That's the flexibility that you have with voluntary document submissions. You lose that flexibility when you're under a subpoena to a large extent, and so generally want to do it under a voluntary format. It's also important to note that it's very easy for OSHA to go and get a subpoena for written documentation. They go to the area director's office, it's a pre-printed form, and basically a couple signatures, very easy to get. So if they don't feel like they're getting cooperation in the document front, that's something that a tool that they have, and like I said, it gives the employer less flexibility with providing information to OSHA. One general rule, there's always kind of exceptions under extenuating circumstances, but for the most part, discourage creating new documents. If the document didn't exist when OSHA walked into the office, then the answer might be this: we don't have this information. There could be exceptions to that rule, especially if creating a new document to provide information and put the employer in the best light. To give them some information. but generally not creating new documents. Don't leave documents in plain sight. When talking about that conference room that you go to have your opening conference, making sure that you don't have your last workplace audits out in notebooks all along in a bookcase along the wall. Just making sure you limit what they have get to see. And if you're doing a walk-around tour, making sure that documents are in the place that they belong. Also, another key rule, and there's an exception here: do not volunteer information. If OSHA asks for a particular document, the hot work procedure, providing them with a hot work procedure satisfies their request. They did not ask for any permits or anything like that. So providing the information that they request and not necessarily volunteering any additional information unless, of course, you've identified an issue in some other document that they did not request would put the employer in a favorable light. And then also, too, reviewing responsiveness, privilege, or trade secret, CBI. Really, the trade secret and CBI issue is really key for FOIA requests. After OSHA creates a document, a case file, and documents go into it, and the inspection's closed and the resolution of the matter is closed, anybody can go to the government and ask for documents to be released under the Freedom of Information Act. And basically, when you put something on a document indicating that it's privileged or trade secret or confidential business information, OSHA will notify you and ask for further justification. So it's just protecting your information and gives you basically a heads up in the event that any individuals requesting that information. And basically limits the number of people that will have the opportunity to see it. Document production. Generally, when we're on a large-scale inspection and even during smaller-scale inspections, keeping a document log, basically tracking the requests that come in, the date that they came in, and then what the response was and what documents were provided to them. Certainly, it does help to number each document so that if there's a discussion later, you can say that a document was already produced, see document page 146. So this is just kind of a master control document that indicates and logs documents produced and numbers on them, something that you find very handy as a large inspection proceeds for a period of time. Okay, turning over.
This is important also as you move into the contest phase. Is so common where we will get involved, counsel gets involved in a contest of citations, and our clients are not able to provide a duplicate set of what they shared with OSHA or even to recreate it if we ask them to recreate it. Having a log like this, keeping a duplicate set, labeling things is a great way of knowing exactly what OSHA has. Because as you're trying to put together your defense to citations, it's useful to know what records OSHA has already seen and what they haven't seen. Just try and understand what the evidence is they're relying on, or what new evidence may be helpful in disproving the citation as alleged. So it's really critical to keep a duplicate set and/or keep a log like this for the next phase of the process as you get into litigation.
And usually, most times I would say generally within the first day or two of the start of the inspection, you'll have some sort of walk-around inspection. Depending on the scope of the inspection will determine how long the walk-around lasts for. If it's just to see one piece of equipment, as Eric mentioned, you'll take them the most direct route to that piece of equipment that minimizes their sight of what's going on. If you have to walk around the building rather than through it, that's acceptable. OSHA recognizes you trying to limit the scope and the purpose of the inspection. Find the most direct route to the area where the walk-around needs to take place. Always accompany the co-show. It's a great way to obtain information when they stop and look at something. You know, is there something you see there? Is there something that catches your eye? Great questions to ask a co-show as you're walking around with them, especially if they're taking pictures. Can you let me know I was directed to take pictures side-by-side pictures of what you take pictures of. Can you tell me what you're taking a picture of? It's just a great opportunity as you walk around the facility to get an idea of what the compliance officer is interested in. It gives you the option and opportunity to present additional information that might show that there's compliance when they believe otherwise. Employee representatives are allowed to accompany the compliance officer as they walk through the facility or to do during their walk-around inspection. I talked about taking side-by-side images. Very important to get an idea of what OSHA has in their case file to determine when, especially in the contest phase, and it's helpful to have the side-by-side images. It's always important to act professionally, but protect your rights as you walk through the facility. If they want to take a detour, if they want to see the general production area and their scope of the inspection does not include it, certainly bring that up to them. And, I'm not comfortable with that. I thought we discussed at the opening conference that this would be limited to the equipment that's outside of the scope of the inspection. So definitely important to protect your rights. If there is or the compliance officer does identify a hazard or alleged hazard during the walk-around inspection, it's okay to take the opportunity and address it to their satisfaction, but do not admit any violation. Don't really provide a lot of additional information. Just take the action, address it, and then move on. And it's always important a lot of times in larger production facilities, refineries, OSHA will want to do a walk-around inspection, but they don't necessarily want to do the company-required training to go in that particular area. We always encourage employers to make them do that training, whether it amounts to watching a video in the lobby. Maybe it's more one-on-one with a safety and health professional at the facility for an hour. We always make the compliance officer follow the same rules as any other individual who enters a particular workplace area. If they have to be in a respirator or if they have to be in some sort of protective gear, definitely require OSHA to follow those rules, and also recommend that they provide their own safety materials and PPE. A lot of times you'll find that compliance officers have a trunk full of safety equipment. So always a good idea. Moving on to the second slide with regards to walk-around inspections, we talked about escorting OSHA at all times. A number of reasons. It keeps them out of harm's way, it keeps the control of the flow of information, and helps you gather information on where the inspection is going and what the compliance officer is particularly interested in. It also allows you to determine if they're going to be taking any air monitoring samples or any dust collection samples. If they are going to be taking such samples, it's a good idea to ask them for advance notice so that you can have similar tools ready so you can take an exact or comparable sample next to where they do for testing purposes. Take detailed notes on what the compliance officer is looking at, the comments that he makes, and then holding daily closeout meetings at the end of the day, which we discussed earlier. Moving on, OSHA inspection interviews. Almost every OSHA inspection does have some employee interviews. Sometimes it's the injured employee. Sometimes it's the foreman or supervisor who oversaw the employee. It's always a good idea to have a general rule. OSHA might stop during a walk around to talk to an employee, but if that conversation starts to move past 5 minutes, it's always a good idea to just kindly and gently intervene and say, I'm happy to set up an interview with this individual at a later time. I don't want to distract him from the work that he's doing at this point, and follow up with OSHA and schedule that interview at a later time. And it also gives you some flexibility and opportunity to prepare the employee for the interview. Usually you want to select some office or conference room for these interviews to take place away from the workplace floor. And, voluntary versus subpoena. A lot of times want to encourage to do voluntary interviews, a lot more flexibility. A lot of times OSHA will ask to speak to a supervisor without identifying who that supervisor is. That gives you a lot of flexibility to present the best supervisor in your opinion, or the one that will be able to handle the questions the best. When you have a subpoena, you just lose the level of flexibility. So always generally work with OSHA to accommodate the interviews. One issue that we run into sometimes is, OSHA is asking to interview a particular employee who is not going to be at work that day. We, basically indicate to OSHA that that person is not on duty that day, but if they could interview them the following day, we could arrange it. So it's a little bit of a give and take, and also letting employees know, especially hourly employees, that it's a voluntary interview. It's we want to encourage you to comply with OSHA, but it's really your decision to participate. They've asked to just talk to you and let the employee know that it is a voluntary interview. They can leave when they feel uncomfortable. They can have water breaks. They can come out and ask questions if there's something they're unsure about. The hourly employee interview, the next page. OSHA demands privacy for hourly employees. They'll be very protective of having confidential, or basically of allowing other employee or management representatives into those interviews. They will allow a union representative if the employer requests it. But OSHA often mistakes the fact that the right for a private interview belongs to the employee, not OSHA. In certain circumstances, when there is especially in investigations that involve a fatality or multiple fatalities, you might want to press the issue with OSHA, and if the employee is willing to allow a management representative to sit on the interview, there is a choice of representation form that indicates, and basically the employee is acknowledging that they're allowing the management representative to sit in on the interview. But always very important to not intimidate employees or require that a management employee sit in. There could be discrimination charges that come back towards the employer. Employees do have a right to have private interviews with OSHA, and there is a provision in the OSHA Act, the Occupational Safety and Health Act, that does protect workers, and OSHA can pursue charges against employers for retaliation. Unlike hourly employee interviews, management interviews, management
real quickly,
does have a right to sit in.
Amanda, 1 second. I just want to emphasize that there is sort of no clearer path to creating tension and adversarial nature of an inspection than this issue about management participating in non-supervisory employee interviews. OSHA hates this. They do not want you in that room. They feel like if you're in the room, the employees are not going to be honest with them. They're going to be scared and intimidated from providing honest answers about, your safety program. So that's why OSHA fights so hard to keep you out, even though it's not their legal right, it's the employee's legal right. This is one of these, just like the warrant requirement, where you really need to do that balancing test in your mind. Is it worth the potential retaliation? Is it worth the tension and the fight that I'm going to have with OSHA to participate in this interview? And there are times where it absolutely is. If you're dealing with a fatality inspection and it feels like it's not going well and there's potential for willful violations which could create criminal liability, and your hourly employees are willing to have company counsel participate in that interview, that is a time to push for it and have your employee sign a choice of representative form and insist that you be present. Often what you see is OSHA say, we're not going to proceed if you're going to insist on this manager or this company counsel being present. We're not going to proceed. We're going to go get a subpoena. And I say, well, that's fine. The Administrative Procedure Act could not be more clear that if you compel an employee to testify, compel an employee to sit for an interview, that employee has the right to have anyone they choose be their representative in that interview. So it is crystal clear that the right belongs to the employee, but understand that's going to create some negativity. There are state programs out there that are okay with that. Federal OSHA goes nuts if management wants to participate in employee interviews, but it is the employee's right. You just need to make sure it's really worth it to have that fight.
And unlike the employee interviews, the management employees, you do have a right to sit in on those interviews, and you don't usually face the same sort of resistance. And if you do, you clearly have a right to sit in on those interviews. And that's because the supervisor or manager's knowledge can be imputed to the employer for violations, for a willful violation. Also encourage that there's no impromptu management interviews. These are certainly interviews that have to be scheduled. So to give proper notice and to allow for any representatives who want to sit in on the interviews time to accommodate the requests. And just stressing that the right belongs to the employer to sit in on these interviews. And then talking about, I think it's generally a good practice to prepare all employees, whether hourly or management, but particularly important to prepare management witnesses for interviews with OSHA. Generally, you'll have an idea of what the topics are, what programs they're going to want to talk about, safety and health procedures, and so it's always a very good idea to talk and prepare employees for interviews. And this is kind of a list of things that we always go over with employees as we prepare them for interviews. As I mentioned before, these are voluntary interviews. They have to be reasonable to schedule. The right to be represented, especially or with regards to hourly employees. The right to not be recorded. A lot of times OSHA will want to take an audio recording of the interview, and we generally discourage employees from agreeing to do that. However, if it's a particularly contentious inspection, a lot of times they'll say, if you're not willing to agree to the audio tape, we'll be back here tomorrow or a few days from now with a warrant or a subpoena for that interview. And certainly trying not to escalate it to that point, and at that point we generally agree to have it audio taped. Also want to be careful with regards to written and signed statements. A lot of times have certainly seen a compliance officer go through an interview with an employee, ask him a variety of questions. He takes his notes and then turns his pad of paper around to the employee and asks him to review it and to sign that it's an accurate statement of what he just said. That's always very hesitant to have the employee sign those sorts of paper. Everybody's notes are going to vary a little bit differently, and that'll become the official statement of the interview. So generally discourage that at all times. Always, OSHA might be asking questions on procedure. It's always fine to ask to review and examine documents. Nobody is required to memorize every particular safety procedure in a facility. One of the cardinal rules is always tell the truth in an interview. One of the things that is always mentioned to employees. And then to listen to the question that's answered and then answer only the question that was asked in short, concise answers. Some very general basic rules when going through a interview with the OSHA that any employee, I think, benefits from hearing before they actually walk into the interview. It also helps them kind of calm their nerves if they have some expectation of what they're going to encounter. So always a good idea to prepare employees for interviews. And then moving on to closing conferences. Closing conferences can be held at the close of the inspection. This might be at the end of the on-site inspection. You also might get a call about 2 to 3 weeks later, could be months later, indicating that they're ready to have a closing conference. Always want to take advantage of these closing conferences. During the closing conference, the compliance officer will go over what they found during the inspection, will identify any violations that they're planning on writing and submitting for or issuing to the employer, and it gives you an opportunity to ask questions about what the alleged violations are. They'll generally tell you what the standards violated are. Depending on how agreeable the compliance officer is, you can get a lot of information from them with regards to the alleged violation. Sometimes the compliance officer is more closed-lipped and willing to we'll give you the basics, which is the standard violated, and wait for them to be issued before further discussion. It's also an opportunity to talk about abatement and abatement dates. Sometimes, although not always, it's important to ask with regards to classifications of the citations, how they plan on issuing them, whether it would be other than serious, willful, repeat. Like I said, some compliance officers are more likely to provide this information than others, but it never hurts to ask. So do encourage you to ask these sorts of questions during closing conferences. A lot of times closing conferences take place over the telephone, which is fine. Moving on to the last slide for closing conferences, this also provides an opportunity to correct any obvious errors, and a compliance officer issuing a citation for a safety policy they believe that you don't have, when in fact that you do have it, or any sort of misrepresentations. That would be a good point in time to provide that additional information to clarify and hopefully get that citation or alleged violation removed before there's an official issuing of citations. It also provides an opportunity to identify any corrections that have been made since the inspection. Once again, as we mentioned during the walk around, you can do the correction, but encourage employers to be careful on what is said with regards to agreeing that a safety violation was made. It's okay to correct, but just not admitting any sort of violation.
We would talk about these as enhancements or improvements rather than corrections.
Right. There's always the possibility, it depends on the time frame of the compliance or the inspection. Request time to offer additional information. A lot of times you find that OSHA is working up against its 6-month statutory requirement in their deadline, but if they're on the ball and they're issuing citations well in advance and you have additional information that you think would resolve the potential issue, it's always reasonable to ask for them to consider it and to submit it to them before they issue the citation. Making no promises about abatement, and then ask about citation classifications and penalties and take detailed notes. A lot of times you'll see a citation that's very vague. It'll mention, in deficiency with such and such a procedure, your lockout tagout procedure, without actually identifying exactly what that deficiency is. So it's always a good opportunity to get more information during the closing conference, and becomes helpful as you're reviewing the citations for potential defenses. Once the citations are issued, they have to be issued 6 months from after the inspection started. That's a statutory deadline that's in the OSHA Act. And if they are issued after that, they are invalid in most cases, unless there's a very extenuating circumstance with regards to a warrant, or OSHA didn't have access to the site for a period of time, but generally it's usually 6 months. The citations can be delivered by hand or certified mail, and it's that delivery date when the employer receives the citation that is going to be key in determining the 15-day contest period where you can consider going into OSHA and having an informal conference. OSHA generally does issue press releases on penalty or citation packages that are more than $40,000, and that would be on the website at OSHA.gov, and are usually picked up in local media. So that's just another thing to keep in mind when you're getting to the end of an inspection and after a closing conference. I'm going to turn it back over to Eric to talk about the last few slides.
All right, so we've kept you a solid hour and a half here. I appreciate everybody hanging with us. Just a couple of discussion points here about sort of what happens after the citations are issued. Going back to my point before that, employers have a right to challenge citations, and OSHA gets it wrong a lot. So thinking about, what do you do when you get the citation? Is this a circumstance where it makes sense to challenge a citation? These are some of the things that I think about. First of all, here's what your options are. When the citation is delivered, you've got an option to just pay the fine and accept the citations. I cannot conceive of a circumstance where that is ever the right move. At the very least, OSHA cuts penalty during the informal conference or in an expedited informal settlement program that they have. So just writing a check and not addressing the citations at all doesn't really ever make sense to me. Requesting a variance, meaning you acknowledge that there's a violation, but there's some reason you can't comply, and you ask for an exception to allow you to continue to operate out of compliance. This is virtually never agreed to by OSHA, so not really a good option there. The other two paths are the ones that make the most sense, where most matters are resolved, I think, in a way that's most favorable to employers. The first is trying to negotiate and resolve the citations by an informal settlement at an informal settlement conference within that 15 working day period, to sit down with OSHA, with the sort of bureaucrats at OSHA rather than the lawyers, the area or assistant area directors, and trying to negotiate a settlement. That used to be a pretty good mechanism to resolve these cases. The National Office of OSHA during this administration has really handcuffed the area directors and limited what they're allowed to offer in settlement, or judged them rather harshly for doing too much in settlement, withdrawing items, changing classifications, things like that. So it is not really anymore a great avenue to get an outcome usually that I think is appropriate, one that protects you from some of the real adverse consequences of an OSHA citation, which we'll talk about in a moment. But it still exists. It's still worth doing, seeing how far you can get the area office to go in settlement, and then maybe using that as a new floor as you negotiate at the next step, where you file a notice of contest and then pick up settlement discussions with OSHA's attorney in the solicitor's office, or actually proceeding to a hearing. It's that process right there where you file a notice of contest but negotiate with OSHA's lawyer, where I have found lately that the best results are being achieved for my clients. You get, an attorney who would have to prove the case, who's a little bit less driven by emotion and more driven by reason and logic and the law than some of the folks in the area office. I feel like you deal with more reasonable people when you're dealing with OSHA's attorney than when you're dealing with the area offices directly. They are less personally invested in the citations. They weren't out there in the field doing the inspection, writing the citation, and feel like, challenging it is a personal challenge to them. So I feel like you get a more reasonable person on the other side of the table, and you get better results that way. So thinking about which of those four paths to take, I think it's important to think about these considerations. One, the penalty. I tend to not ignore the penalty, but this is not the most important thing to me when I'm analyzing a citation, but often it is for smaller, mid-sized employers, or if OSHA is just way off the reservation in the initial penalty. It's something to think about. Is the penalty too high? That's something you can address through negotiations, something you can challenge. Other, so perhaps more important considerations, though, is the abatement clear? Is it feasible? And would it put you at a competitive disadvantage? If the citation you think is wrong, or basically what OSHA is demanding that you do would require you to change your operations, change your equipment, or implement some sort of administrative process that your competitors are not required to do, that the law doesn't actually require you to do, or that would be too expensive or infeasible, that may be a situation where you've got to challenge the citation, because while it may carry a $3,000 penalty, it could require you to implement a $400,000 capital project to address the physical change. And so you're not negotiating over a $4,000 penalty, you're negotiating over this giant capital project. The other thing, and again, if you had a chance to participate in our last webinar about repeat violations, you know how critical this issue is now. That this is OSHA's, I think, number one, new weapon in enforcement, ways to drive penalties through the roof, ways to really influence or really impact employers is through repeat violations. So you've got to look at the citation you get, and this is a mistake I think employers make all the time. First citation they get, it's characterized as other than serious. The penalty is negligible. Maybe it's even in the hundreds of dollars. Or you go in for a serious violation with a meaningful penalty, and OSHA agrees if you take the violation, we'll call it other than serious and we'll cut the penalty. You think, well, this is a great victory, not thinking about what's going to happen a year from now or 2 years from now if OSHA revisits the same site or visits one of my sister facilities and finds a similar issue and issues it then as a repeat violation. You've got to consider what's going to happen next. Is this citation A, do you agree with it? If it's wrong, you don't want it on your record because it sets you up for a repeat violation the next time, possibly qualifying you into the severe violator enforcement program because multiple repeat violations will trigger this horrible thing called SVEP that we're going to talk about in a separate webinar coming up soon. But look at each violation and think, how can this impact me in the future, rather than just thinking about what's the current penalty and current classification. Is this in an area that we do a lot of work? Does it involve equipment or an operating process, requirements related to those things that we do a lot of? And think about, is this something I really want on my record? Is it something that's likely to come up again that we could get bitten in terms of a repeat violation? To me, that has been a fundamental change in my practice, is analyzing citations not on their current basis, but on what they may become later. And if it's something that we're worried about becoming a repeat violation, we fight it much harder in the first instance. So that's something to consider as well. Talked about the competitive disadvantage already. Perhaps impact on civil litigation or workers' comp issues. You've got workers' comp statutes out there in a lot of states, or workers' comp exclusivity bars, exceptions to those exclusivity bars in a lot of states that might use a willful OSHA violation to either circumvent the exclusivity bar and allow a personal injury suit, or just the willful violation itself, resulting in a multiplier effect on the workers' comp recovery. So think about how the OSHA citation might affect civil litigation or workers' comp disputes, and understand that you may need to challenge a citation or the characterization of a citation to protect yourself from a civil suit, or even a willful violation, protect it from becoming a criminal prosecution. Likewise, think about how the citations may affect your insurance premiums, or much more importantly now, the contracting pre-qualification process. You will no doubt, you're on my list, you're going to be getting a notice from me probably in the next day or two about a very, very important new regulation that has just been proposed that we are putting together a coalition to comment on, and this is the FAR Council government contracting. A lot of people are calling it the blacklisting regulation, where now the Department of Labor and all of these government agencies that private entities contract with have put out a regulation now that requires you to report labor violations during the bid process for government contracts. And it's basically a way of forcing you to report your OSHA violations, wage and hour violations, things like that, even if they're just alleged violations that haven't been proven, that you have to report these to the contracting agency, which may result in debarment, may result in disqualification from bidding on the contract, or if you look at this regulation, may require you to engage in something called a labor compliance agreement, which is an invention in this new regulation, which I look at as a pretty clear backdoor route to an injury and illness prevention program requirement, which OSHA has tried for years to do through rulemaking, but has been too controversial to get it through. Well, this regulation is a way to force that. But my whole point here is that citations, even relatively minor citations, now have the impact of affecting your ability to bid on government contracts and even private contracts. There's a lot of private contract bidding out there, especially in the construction context, where your OSHA record is a major component of qualifying for contracts. And there are third-party groups out there that are hired by general contractors or owners or prime contractors to basically evaluate your OSHA record. And if you have even one serious violation, I have seen that one serious OSHA violation will disqualify you from bidding on private government contracts, and one serious violation on your record will require you to report under this new FAR regulation. So that's a very, very important reason to evaluate citations, even what seem like relatively minor citations, and think about, is this something I need to challenge? Is this something I need to correct or get off of my record because of all the different ways that it could impact me in the future and impact my business? So we've thrown a lot of information at you. I'm going to open it up for questions here. I know we've got a couple of them sitting in the queue right now. I'll read those off and address them. But I will offer a couple different things. One, on our website, connmaciel.com, we have a tool that we have put together called our OSHA Inspection Toolkit. And it is sort of a desk reference guide that covers a lot of the topics we talked about today. I definitely recommend you get a hold of that. I will probably include a link to it in our follow-up email. But that's a great way to sort of cross-reference in a couple of pages a lot of the tips and strategies we talked about today. The other thing I'll throw out there is that obviously I don't want to insult Amanda, but I will speak for myself and say I'm a huge OSHA nerd. I love talking about this stuff. Many of you have heard me say that before. It's true. Many of you have taken advantage of that and called me and just had what to me are really interesting conversations about issues that you're dealing with out in the field. That's the way I learn about, what OSHA is up to. So I welcome those calls. Please don't ever hesitate to call me, shoot me an email, ask me interesting questions, or share your experiences, something that you saw in an OSHA inspection or saw in an OSHA violation that you thought was unusual or worth talking about. Chances are very good I'm going to be very interested in hearing about it too. So I'm going to cover a couple questions and put up here Amanda's and my contact information so you all can reach out to us after today and talk about that sort of stuff as well. We got one question here that talks about sort of the link between the OSHA consultation program and OSHA enforcement. Essentially the question is, if you invite the OSHA consultation program in for a voluntary visit, this is the non-enforcement compliance assistance side of OSHA, and they do an audit, and you correct all of the issues found, or if you don't correct either way, so let's say you don't correct all the issues found, and one day OSHA enforcement visits on an employee complaint or an inspection program or whatever, and they find the same issue. Is that considered a repeat or willful citation? I can tell you for sure that cannot be the basis for a repeat violation. There has to be a final order of a substantially similar violation, usually a violation of the same standard under similar circumstances, a final order of the review commission to serve as the basis for a repeat violation. So a finding by the consultation program of a compliance gap cannot serve as the basis for a repeat violation. Now, whether it can help support a willful violation, I would say that it can. Generally speaking, enforcement is not supposed to have access to the findings and the reports and the recommendations and your actions taken as part of the compliance assistance program, but I've seen it happen before where they get it. Sometimes they'll get it if the compliance assistance program feels like you're ignoring their recommendations. They might make a referral over to enforcement. If they do that, or if they just violate their protocols and get access to those types of records, or if you accidentally or deliberately share with OSHA that reports from that consultation program, that can be used against you in a subsequent inspection. And I think it is exactly the sort of thing that OSHA might look at and say, well, you knew about it, you didn't address it, we think that's some evidence of willfulness. It's going to be rare because there is supposed to be a wall between the two, but if they have information, if they have knowledge that you have previously been made aware of these compliance issues and you haven't addressed them, then yes, they can use that as the basis for evidence for willfulness, evidence of knowledge to support a violation, but not as the basis for a repeat violation. Very good question. Another question here, somebody asked about when you say prepare a witness for an employee interview, what is allowed? Basically there's no rules around it. The only thing that is not allowed is intimidation, coercion, and retaliation. If an employee tells you, I am not comfortable sitting down and talking to you at all, then I would not force them to do it because that could be perceived as an 11C violation, taking an adverse employment action, intimidation, coercion related to an employee's participation in an OSHA inspection. So you want to avoid that. But if the employee is willing to sit with you, there's really no limitation on what you talk about. OSHA might be ticked at that. I've heard them, say, you're not supposed to, debrief from a private employee interview. But if the employee is willing to talk to you afterwards, willing to talk to you beforehand, that's the employee's right. And if you're not forcing them to, and if they're aware that they've got a right to keep their interview private, which you'll tell them and OSHA will tell them, then there's nothing wrong with that. So to me, it's sit down with the employee, go over those interview rights and those interview tips that Amanda talked about, and review substantive issues. I mean, to me, it is astonishing to me. Well, I guess it's not anymore, but it used to be astonishing to me how no matter what training you've provided to an employee during an OSHA interview, they will have remembered receiving no training at all. I mean, not even getting an answer wrong about the training. I've never been trained on that. Is like 100% the answer they're going to give, even if 3 days earlier you had a video and a test and a classroom exercise and a hands-on exercise. They never remember training, or at least they, deny it during interviews for whatever reason. So I'm going to sit down with them during this prep session with records and say, do you remember the training? No. Well, here's the documentation in the video we showed you. I don't really remember it. Well, here's the sign-in sheet with your name. Is that your name? Yes. Oh, okay. Well, I guess I remember now. And here's a test that you took where you answered questions about it. Oh, okay. I guess I do remember. Nothing wrong with that. You're not introducing something new. You're not telling them to lie. You're refreshing their recollection, and they need it. It's unbelievable to me how little employees remember about your written policies and about your training. Nothing wrong with refreshing their recollection before an interview. So I would encourage you to sit down, use records to refresh their recollection, training documents, written policies, whatever it takes to review those substantive issues so that they're giving positive, productive, accurate answers during the interviews, and you're not, they're not lying, they're not making stuff up, you're not making stuff up, but use that prep session to really get them ready for the interview. I don't see any other questions. If any others come in, we'll address those, but of course, as always, shoot an email to Amanda or me, give us a call. We're always happy to talk about this stuff. Last thing I'll say is, check out our the remaining topics in our 2015 OSHA webinar series. I hope you can join us for some or all of those programs. Look out for an email from me shortly with a link to the recording for this webinar, the slides, and our inspection toolkit. And also look out for, soon for information about this new FAR blacklisting regulation. And we're going to be inviting folks, individual companies and trade associations to join us and our other clients and contacts in a coalition to submit comments based on those. I think it's going to be a incredibly impactful rule. There are elements of that rule right now. I think it's a laudable idea. I think the written regulation and the guidance around that regulation right now are dangerous. They go way too far, and they are basically using this as a Christmas tree to allow OSHA to accomplish things that it has not been able to accomplish through the rulemaking process on an individual substantive basis. So we are going to need to have a strong voice from industry addressing this rule and pointing out some of the things that we think are unfair, are burdensome, are improper, and I invite you all to join that. So look out for a communication from us about that. Thank you all for joining us today. This was a lot of fun, at least for me. I don't know if Amanda's relieved that it's over, but I always enjoy these, and I enjoy the interaction with you all. So look forward to visiting with you again soon, and don't ever hesitate to reach out to us if we can answer questions, or, of course, if we can help you with an OSHA issue that has arisen at your workplace. Thanks again, and we'll talk to you soon.